Good evening, ladies and gentlemen, and welcome to the December 17th Merrimack Zoning Board of Adjustment. And the next ZBA meeting will be January 28th of 2015. So, Tony, would you lead the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And Patrick, would you read the preamble, please?
By all means. Good evening, ladies and gentlemen. For those of you who have not attended these hearings, the procedure is as follows. The petitions will be heard in the order that they are posted in the legal notice. Excuse me. However, the chairman may change the order with consent of the board to expedite the public hearing as appropriate. We allow each petitioner to state why his or her petition should be granted. Following the petitioner's statement, any abutter or interested party is allowed to speak for or against the petition. In the interest of getting all the facts, we will go around a second time. The board may elicit testimony at any point, but we cannot allow any cross-examination. All questions must be directed to the board. Also, we ask that you do not repeat yourself or your neighbor's testimony. If you wish to just indicate concurrence, please do so. After hearing all the facts regarding a petition, the chairman will close the public hearing and the board will deliberate and vote on the petition before moving on to the next petition. The zoning board is empowered to legalize the breaking of the town's zoning ordinance, and this is not done lightly. State law and local ordinances are set out the criteria that must be met in order for this board to grant your petition. I remind you that it is your responsibility to prove your case so that this board has justification for granting the petition. The minimum requirements are listed in the form you receive from the Community Development Office, and it will be helpful if you would proceed on that basis. Please turn off all cell phones. Would all those who plan to testify please stand to be sworn in? If you plan on speaking this evening, please stand to be sworn in. Raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God? Madam Chair.
Thank you. And just as a reminder, please turn down all cell phones and pagers. And before we go into the variances, etc., Lenny, would you sit in for Phil tonight, please? And with regrets, we've accepted Phil Straight's resignation from the zoning board. And we're going to hold the election for vice chair before we go into the variances. Would anyone like to make a nomination?
I'd like to nominate Patrick. Anybody?
Anyone else?
Well, I wouldn't mind taking the spot myself. So.
I'll nominate Tony. Run against you.
You want to get me?
Yeah. Rock, paper, scissors.
Okay.
All right, any other further nominations? Oh, anyone voting for Patrick?
I'll vote for Mike. I'm not going to vote for myself.
So,
Just me?
I think it's just you and Lenny. Lenny raises his hand.
okay, 2 votes for Patrick.
At least it wasn't sweet.
And who's voting for Tony?
I ain't going to vote for myself.
Oh, I'm voting for you.
If that's true, there's going to be 2 hits too. Or stymie.
Well, I'm not voting for you either.
Thanks, guys.
So Patrick's-
I'm going to let you, since it's 2-2, you guys, whoever wants it.
It's all what you want to do.
You want to take it?
You want to take it? I'll take it.
Can we use the rock, paper, scissors methodology? Best 2 out of 3?
Want me to take it?
Just let me know who's going to be my vice chair, please.
Patrick says that, why don't you take it, so I will take it.
All right, thank you. Tony Pellegrino is the vice chair.
Do you want to switch seats?
Yes, could you please?
Well, would I?
Yes, would you please? I won't let him touch him.
There'll be a small party after the meeting. I'm willing to take presents, money.
Tony, get over here and sit down. And any presents you give him or any monies will be returned to you, guaranteed.
No, that ain't mine. It's hers, that ain't mine. I'm sorry for this interruption, but switch her out. Okay. Switch?
Hey, Christmas is coming too, guys, huh?
All right,
Are we all set now?
just a minute. Go, Madam Chair. Go ahead, Chair.
Thank you. All right, the first item on the agenda is Lynn M. Waller, petitioner, variance under section 3.02 of the zoning ordinance to permit a single-family residence lot, resident lot without the required 250 foot of frontage. Excuse me. The parcel is located at 9 Leicester Road in the R1 Residential District, tax map 4B, lot 014, case 2014-48. And Attorney Michael, you'll be speaking on this?
I wouldn't want anybody to miss what I might have to say. Thank you, Madam Chair. Attorney Greg Michael, on behalf of the petitioners, along with Michael Cass from my office, I'd like to give you a brief overview of what this is, and I'll have Mike take you through the 5 criteria. This is the Waller property located on Leicester Road, and I've shown you, I delivered to staff the kind of the plan of this. It gives you the outline of the existing 6-acre parcel that the Wallers have owned for some time. And again, I've given you an orange line showing one of the lots. The yellow line shows the proposed new lot that does not have a dwelling on it at this time. The issue before the board tonight under 3.02 of the ordinance relates to frontage. We have, the way we've set this up, rather than create some sort of a, I'll use the term Mickey Mouse pork chop slicing off a piece and going to the road, is that we end up with 151 feet of frontage on the new yellow lot. We're left with 295.87, which is quite frankly more than we need, 45 feet more than we need for the orange lot. I would point out that this parcel is rather unique kind of in the area. It's actually one of the few larger parcels, and there aren't many larger parcels here. Most of the parcels, the minute you move over here, there's a subdivision that has smaller lots, smaller frontage. I believe it's a cluster. There's one out in this quadrant also. So the area really is made up of a kind of an eclectic mix of lots. The couple of larger lots are not really rectangular. They've got funky shapes and designs. How that happened, I don't know. These lots were created some time ago. But in point of fact, this is one of the few kind of large rectangular lots, if you will. And as you can see, the proposal is for 2 lots that, again, more than meet the current requirements for lot size here in Merrimack. Size is not the issue. I would also point out that any house location is not the issue. The setbacks will be met. We're not requesting setback variances. The depth is met. The only issue relates to the frontage. As you can see, Leicester Road has kind of a sweeping curve. As you can see from the plan, if you look at the overview, you'll discover that the site distances are quite good in this area. It's certainly not a bad area for the lot to exist. I'm showing you this. This is a shot kind of from the rear out to the road so you can see the roadway. And what this does is it gives you kind of an overview of the area in question. It's good dry land. In the old days, this would have been slight soils. In the old days, 40,000 square feet, 150 feet of frontage, interestingly enough, and you could build in the old days. When we changed to some soil-based zoning, this became severe soil, and the rules of engagement kind of changed. But I only point out, I find it fascinating that if this were slight soils, we wouldn't need to be here. Which, of course, now begs the question, how relevant is frontage for this proposed lot? And that's what Mike and I will be discussing with you. But I just point those salient facts out because I was around. It's almost New Year's, and by the way, happy holidays, Merry Christmas to you all. And I'm hearkening back to one of my first appearances here in 1977. Do we all go back that far?
Oh, yeah.
I know you do, Madam Chair. I know you do. Tony's been around a long time. Lenny's been around. But anyway, in point of fact, it was different then. And back in those days, we would not be here. 150 feet, that would have been slight soils. We would have been able to build without it. So I kind of bring that up as points in the background of this. We'll be looking at a number of factors, and including, there's a couple of cases that are interesting. They're actually kind of fascinating that the Supreme Court has ruled on. There's very little in the way of frontage litigation. I want to point that out to you. And part of the reason for that is I believe that the boards and this board as well, have acknowledged, is the frontage really irrelevant in some of these cases? And our Supreme Court, before Simplex, this predates Simplex, which of course loosened up the hardship criteria. Justice Grimes, in the case of Metzger versus Brentwood, wrote an interesting opinion, and it is directly a frontage-style case. And in it, he states, as part of the ruling, it's the holding, and they're talking about the regulation. I think this is important. He says this is not to say that there cannot be reasonable regulation under the police power. The police power is what allows towns to adopt ordinances and restrict people's property rights. It is to say, however, that the restrictions and regulations cannot be unreasonable. Well, that makes sense. We talk about that now many years later from 1977. When the restrictions as applied to a particular piece of land is unnecessary to accomplish a legitimate public purpose, or the gain of the public is slight, but the harm to the citizen and his property is great, the exercise of the police power becomes arbitrary and unreasonable, and this court will afford relief under the Constitution of the state. Those same terms, interestingly enough, are what you hear many evenings here, many years later. These concepts have now been embraced, and the concept of not contrary to the spirit, not contrary to the public interest within the spirit of the ordinance. And he goes on to state, this is such a case. Here, so long as the driveway, let me give you the facts, it was a driveway that was going to enter off the Class 5 portion, the public portion of the road, was only had 153 feet, 200 feet were required. Remarkably similar in some respects to this. Remarkably similar. Here we've got 151, 250 is required. I understand that. But here, they said that as long as the driveway that leads from part of the road, access to any residence the plaintiffs may build upon his property is unaffected by the fact that they have 123 feet on the road instead of 200 feet. They looked at this and said, this doesn't make any sense in that case, this case. And he talks about a couple of other older cases and one out-of-state case, and he states, interestingly enough, they're the excuse for upholding the restriction, in other words, upholding the frontage that was needed, was that the prohibited activities would harm the public. No such situation exists in this case. The building of a single-family residence on plaintiff's land would cause harm to no one. That's the court talking now, not me. With that background in mind, I want to defer to Mike to have him kind of take you through the requirements. But we firmly believe that, taking a 6-acre parcel, which is now large by, I would say, by Merrimack standards, because we've subdivided a lot of land in this town. That's no secret to anybody. But this particular parcel can easily support one residential single-family dwelling. I would point out the use is permitted. We're not talking about a use situation here. The use is permitted. The only issue is frontage will be able to meet all of the other requirements. Thank you.
That might help. I assume you heard the beginning. My name's Michael Glass. I'm an associate with Bernstein Sure. And tonight I'll be discussing with you the, excuse me, the 5-point variance criteria as it applies to 9 Leicester Road. Beginning with number 1, granting the variance application before you will not be contrary to the public interest. The question is, what does that mean? Courts have stated that to be contrary to the public interest, the variance must unduly and in a marked degree conflict with the ordinance such that it violates the basic zoning objectives. Now, of course, the next question is, what are those zoning objectives with respect to frontage? And as Attorney Michael cited in the Metzger case, and the courts have subsequently and repeatedly sort of discussed the purpose for frontage requirements. They did again in a case titled Hannigan versus the City of Concord in '99. The purpose of frontage is twofold, according to this case law. First, it's to provide safe access. And second, it's to determine lot size to prevent overcrowding. Regarding the safe access requirement, the proposed lot before you has 151 feet. Together with the road site distance, that frontage allows for all permitted uses as well as any emergency uses. There's more than enough frontage there. Regarding the lot size, to prevent the overcrowding issue, the proposed lot's sole dimensional nonconformity is frontage. Its lot area and all other dimensional requirements are satisfied, and as such, overcrowding is not a concern. In light of the above, allowing the variance application will not be contrary to the public interest, as all the frontage zoning objectives have been achieved. If there's any questions, happy to take them at this time.
We will be stopping after each item, so if you
Okay,
could just...
and so I'm done with 1.
Any questions? All right, go ahead.
Okay. Moving on to number 2, this application does embody the spirit of the ordinance, and the spirit of the ordinance is observed. Again, the purpose of the frontage in connection with other dimensional requirements, such as the lot depth and the setbacks, which we are in conformance with, is to allow adequate access and to protect from overcrowding. Here, the proposed lot contains more than adequate frontage to allow for safe access and safe emergency access. And given that the proposed lot satisfies the minimum lot area and all other dimensional requirements, there are no overcrowding concerns. Moreover, the shape and the size of the proposed lot are consistent with the surrounding neighborhood. And it's notable that if this lot was located on town water and sewer, it would require only 150 feet of frontage. And I think that highlights how the proposed lot observes the spirit of the ordinance. Any questions on 2?
All right, go ahead.
Okay, thank you. Moving on to 3. Granting this variance will do substantial justice. Substantial justice is done when the loss of denying a variance exceeds the gain to the public in strictly enforcing the variance. Denying this minimal frontage variance request will not result in any appreciable gain to the public because 1, this existing lot is an oversized residential lot consisting of 6 acres. The 151 feet of proposed frontage will allow for safe access for a residential lot. And 3, the proposed lot will be used consistent with the district's permitted uses and the uses of the surrounding neighborhood. Moreover, denying this request will result in substantial loss to the applicant by preventing the reasonable subdivision of a very large residential lot. Here, the loss of denying the variance greatly exceeds any gain to the public and warrants the requested variance.
Go ahead.
Thank you. Moving on to 4. The values of the surrounding properties will not be diminished by allowing this variance application. The variance is not going to alter the character of the neighborhood, which includes a few irregular large lots and many more small lots which rely on smaller lot areas and smaller frontage. The permitted uses in this district will not produce significant traffic, noise, or odor, and the proposed lot again meets all other dimensional requirements.
Good.
Thank you. Fifth and finally, denying this application will result in unnecessary hardship. Again, as Attorney Michael mentioned, this is a unique property. It's oversized, but of regular shape, inadequate frontage. It's in the same neighborhood as a few large, irregularly shaped lots and many lots that are smaller and rely on minimum lot frontage and lot area. With respect to 5A1, there's no fair or substantial relationship between the purpose of the ordinance and the facts of this application. This relates to the first discussion we had concerning how the application is not contrary to the public interest. Again, the objectives behind frontage zoning is to provide safe access and to determine, to provide a tool to make sure that the lot sizes are not overcrowded. As applied in this case, safe access, it's not an issue. The 151 feet is adequate for the permitted uses and for safe emergency access. And the lot size and overcrowding issue is also not a concern because the lot area requirement is satisfied and this lot is consistent with or larger than many of the other lots in the neighborhood. In conclusion, the facts of this case show there's no fair or substantial relationship between the ordinance purpose and the pending application. And with respect to 5A2, this proposed use is reasonable because it's permitted under the plain language of the ordinance. Any questions on 5?
Right, since the board has no questions, I'll open the public hearing on this. Is there anyone who'd like to testify for or against this variance? Right, I'll close the public hearing.
That's yours. Motion to
Motion.
approve. Lynn M. Waller, petitioner, variance under section 3.02 of the zoning ordinance to permit a single-family residential lot without required 250 feet of frontage. The parcel is located at 9 Leicester Road in the R1 Residential District, tax map 4B, lot 014, case number 2014-48. Staff's recommendations, the applicant shall obtain subdivision approval from the planning board for the proposed 2-lot subdivision, if approved.
Have a second? Second. Okay, second is Lenny. All in favor, say aye. Aye. Anyone against? Any abstentions? 500.
Thank you very much. Appreciate your time tonight.
Thank you.
And we don't have to mention the 30-day. I thought so.
Have a good holiday.
Yes. The next item is Kevin Dugan. Am I pronouncing it correctly? Is Kevin Dugan here?
Duggan? Kevin Duggan?
Duggan? Dugan?
Going once?
He didn't call or make any notification? We'll hold it till the end of the meeting. If he hasn't shown, we'll table it. The next item is Robert T. Bevel, petitioner, request for a rehearing regarding case number 2014-40, in which the board voted to deny an appeal of administrative decision seeking to overturn the Community Development Department staff decision to classify a firearms service, maintenance, transfers, and assembly business as being eligible for a home occupation which allowed by planning board's approval of such business located at 11 Blair Road in the R Residential and Aquifer Conservation Districts, Tax Map 6C, Lot 170, Case 2014-53. Any of the board members have any comments? I may be wrong, but I believe I read in the Telegraph that the subject who wanted to only open the gunsmith shop was going to withdraw his petition to open it. Now, am I correct on that, Jillian?
That's true, but we still need to consider this request for rehearing because this
No,
has to do with
but I
the
just wanted to make it
staff.
clear that he withdrew his petition to open the gunsmith shop.
That's true.
Okay. All right, do I hear any comments from the board on this? Do I have a motion then?
Jillian, what are you looking for us tonight to make,
We have to,
to uphold what the staff, or,
This is to decide whether to rehear the case.
oh,
It's
it's a mute point, isn't
mute
it? If
point.
he's
It's a mute.
withdrawn his petition to open the shop.
He has said that he may come forward with it again in the future, so
Then you can petition it again. There's no sense of rehearing the case. If the guy's withdrawing, if the guy decides to move forward, then we'll hear it at that time.
we need to decide on the staff's decision to classify the firearms business,
Oh, okay.
which is why the request for
Okay,
rehearing.
that's
was-
basically what this is whether we're going to classify firearms as a home, a gunsmithing business as a home occupation.
The decision tonight is whether to hold the rehearing or not.
The statement that's here is that the reason for the request is due to the fact that our first decision was of these three items, that the petitioner's civil rights have been violated, municipal estoppel, and a prospective argument about the future reapplication for a home occupation by the original applicant and the manner in which it may be processed. So those are the three reasons that we're doing this. So the question then is, do we feel that's...
Well, number one, we can't do anything in the future. We're here and now. We cannot vote on what's going to happen in the future.
Okay, so that's...
So that is a moot point, that we can't even look at that because we don't know what's going to happen in the future.
Agreed.
Lenny, you have anything? Tony? Patrick?
Hold on a second. I'm just okay. I don't have anything else to add.
Pardon me?
I don't have anything else to add.
I would say that the third point, what you made, is accurate. Civil rights, we could debate that all day. And then the third thing that we need to really determine is municipal estoppel. I don't see that.
Tony?
I agree.
All right, so may I have a motion?
I'll go for it. I'd like to make the motion to deny Robert T. Bevel, petitioner, request for rehearing regarding case number 2014-40, in which the board voted to deny an appeal of administrative decision seeking an overturn the Community Development Department staff decision to classify a firearm service, maintenance, transfers, and assembly business as being eligible for a home occupation, which allows the planning board's approval of such a business located at 11 Blair Road in the R Residential and Aquifer Conservation Districts, Tax Map 6C, Lot 170, case number 2014-53.
All right, and before I go for a second, would you just explain why you made that motion?
The purpose for the motion is based on the three criteria that relate to our original motion as just not being accurate.
All right, I just need a little more for the record that you don't believe about future reapplication.
I don't believe that this is something that we can discuss future applications on, because we do operate on a case-by-case basis. I think referring to it as a municipal estoppel is not accurate, and I think that the petitioner's civil rights have not been violated in any way by this decision.
Okay, and now do I hear a second?
Second.
All in favor to deny the rehearing of Robert T. Bevel, say aye.
Aye.
Anyone against?
Aye.
Okay. 4-1-0. The next item is 480 DW Highway. And please excuse me if I pronounce this wrong. Chiruri Realty. Is it Maddie?
Yes.
E. Chiruri. I'm sorry. I know I'm trustee, petitioner owner. Special exception under section 2.02.2C of the zoning ordinance to permit a restaurant in the C1 district. The parcel is located at 480 DW Highway in the C1 Limited Commercial Aquifer Conservation Districts, Tax Map 5D-3, Lot 046, and it would be our case number 2014-54. And if you signed in on the sheet there also, sir? Yeah, on the clipboard, would you sign in? And you were sworn in, correct?
Yes.
All right. Why don't you have a seat, and if you would start with the 5 points of law that you filled out here,
Okay.
and then we'll go into questions also.
My name is Mahdi Shweri. I'm a resident of Merrimack since 2000, and I reside on 480 Daniel Webster Highway. I would like to address the board. I would like to establish a full service restaurant at which will seated approximately 40 people. This location was formerly as a restaurant a while back, used to call the Pizza Man. Everybody know the Pizza Man. On 480 Daniel Webster Highway is an excellent location for a restaurant. There are no other Lebanese, French style restaurant in the area. I will be excellent for the community to experience desire food choices, and will also make a Merrimack more destination for people who live outside the community. This location
No,
was...
could you, just a moment, we're going to ask you, see if there's any
Okay.
questions before each, in between each one. Any questions?
No. Well,
No? Okay, go ahead with number 2.
Okay. This location was formerly as a restaurant. There is a plenty of parking in the existing lot. I do not plan to change footprint or the building. The restaurant will be positive for the neighborhood as it will other walk-in dining options. Excuse my English. I'm not too good reading.
No problem.
That's okay.
It will be offer a walkable dining option for a neighbor. The senior next door, MCA plant, across the street.
Okay, just a moment. Any questions? All right, go ahead with C.
The parking lot is located behind the building, which has an entrance of Church Street. This lot will be safe for vehicle and customer. There is no need for street parking.
Questions?
no.
I just have one, and I know it's really not relevant, but the small area that you have for a parking space in the
Yes.
back, because I'm very familiar with that, it doesn't seem like it would hold too many cars.
It's, I have a little plan. It's showing 14 parking.
Okay, and that's only on your property and not on the seniors or the church?
No.
Okay. All right. All right, why don't you go ahead with D?
Okay. Having a restaurant in Paris, France, I'll plan and having top-notch kitchen equipment and another trend pleasant dining atmosphere. I plan on meeting all the requirement of wheelchair access, restroom. Please see picture of the
Facade.
on the side, whatever I wrote down.
It's a big difference from the old pizza man.
Pardon me?
It's a big difference from the old pizza man.
Well, you know, if the board allow me to do it, I'm gonna call it La Terrace. It's the only place in Merrimack, any place in Merrimack, any restaurant in Merrimack, you go in, you sit inside closed door. The only place you're gonna go to sit in a restaurant and you could see a view, it's in that picture. You could sit in the restaurant and eat, and you could look outside. I don't know. I have. I don't know if I submit picture with you. Anybody has pictures?
Yeah, we all have pictures. They're all in
okay.
our packet, yeah.
Yeah.
It looks beautiful. It really does. And what's the translation on the name of the restaurant?
La Terrace, it means the porch.
The porch. Okay, that's- I
have
still
a-
remember
I-
the old pizza man.
I have a picture of the food.
Yeah,
I'm
we
gonna
have
show
that
you.
also,
Oh,
yeah?
okay.
Yeah.
It's gonna be something different for the town. Probably gonna take me 6-7 months to do it. I'm gonna try. You know, a while back I took 455 Daniel Webster Highway, used to be an old gas station, me and my brother. And you could look at it now, it's a beautiful place. Used to be a dump. Now it's nice building. Everybody happy from it. And a while back when I took the 480 Daniel Webster Highway, used to be like a shack. Now it's a beautiful building. The only problem still have it's the frontage. It's all changing wood, new ceiling, new roof, new everything.
Okay, so any questions or comments? Lenny?
Just a clarification, nothing jumps out and tells me. The restaurant is proposed for the lower level?
Yes.
Okay, thank you.
And the handicap is up on the parking in the back of the building.
It's gonna be, later on will be a plan where it's showing the stairs coming around and the handicap coming around, and will be canopy on top of it, will be look good. You could see it on the side of the build, on the left side of the building. It's gonna be in this area here where it's gonna coming down the stairs, and stairs with a railing and for wheelchairs to come in.
All right, since there's no questions from the board, I'll open the public hearing. Is there anyone who would like to speak or for this restaurant or against it? Close the public hearing. May I have a motion?
Motion to approve 480 Daniel Webster Highway, Chori Realty, Maddie Ichori, trustee, petitioner owner, special exemption under section 2.02.2C of the zoning ordinance to permit a restaurant in the C1 district. The parcel is located at 480 Daniel Webster Highway in the C1 limited commercial and aquafire conservation districts. Tax map 5D-3 lot 046, case number 2014-54, with a special exception. Should the ZBA vote to grant this exception, staff recommends that the board grant it in the following conditions: the planning board approval or administrative approval, whichever is deemed appropriate for change of use.
Second.
All right, all in favor, say aye.
Aye.
Anyone against? 500.
Congratulations.
Your restaurant
Thank
is
you very
approved.
much. Anyway, I wish every one of you happy holiday.
Thank you.
And
Thank
I
you,
hope
and
next
same to
year
you,
will
sir.
bring to the town better years, better business.
Yeah.
Thank you very much. I appreciate it.
Have
Thank
a good
you.
night. Thank you.
Yeah, he's got to put Yeah, but we had memories there. Used to bring the kids there. Thank you, sir. Frederick Hayden? We're going to take this a little out of order. We're going to take your last variance request first, yeah. So it's Frederick and Kristen Hayden.
Christine, yep.
Christine, okay. Hayden and Donzie, is it?
Yep.
Realty LLC petitioners owners for a variance under section 1.03A3 of the zoning ordinance to permit the construction of a 5,000 square foot garage barn not incidental and subordinate to the principal dwelling of the residents. The parcel is located at 7 Priscilla Lane in the C1 Limited Commercial and Aquifer Conservation Districts, tax map 6D-2, lot 004. Case number 2014-56. And also, if you would go through the points of law, and then if you'd stop after each one, and we'll ask questions if we're curious. How's that?
Good evening, Madam Chair, Vice Chair, and the board. Thank you very much for taking your time all the time to sit through these. My name is Fred Hayden, 5 Priscilla Lane, as you heard. been living at that address with my family, wife, and 2 children since 1989.
Oh, you're still a newbie.
Yeah, yep, exactly. Recently purchased 7, which is right next door, and that's what this is, I'm here tonight for. I guess we'll start with number 1. Granting the variance would not be contrary to the public interest. The side setback is against the highway property. No structures will likely be built on the state land, and no person will be moving into that property. The structure will not act as the structure will act as a noise barrier from traffic, and the land on that side is really not suitable for quiet enjoyment. I'm asking to place a new structure no closer than the one that exists, only 30 feet longer.
Hold up.
Is that your?
Is that this is the second one, right?
Yeah, this is the 2014-56.
You just read 2014-55.
So the other one is the first
Yeah,
one?
we had to,
Okay.
on staff recommendation, they said we should hear this one first.
Okay, and this is that's the setback one?
This is the,
Building within the setback is the one you
is
want to
the
hear?
first one. We're looking for the construction of a 5,000 square foot garage barn.
So the first one is the size.
Okay.
Second will be the setback.
Because if the first one doesn't go through.
Right,
there's
yep,
no sense in
I
setback.
understand that. You know what? She made me a copy of I thought this was the one, so I don't have a copy of the second one.
Well, you can read that one. Okay.
Okay, so all right, we'll start this again. Ready?
Go ahead.
Okay, granting the variance would not be contrary to the public interest. 3 of the 5 houses on the street already have garages that are 2,500 to 3,000 square feet or more, and the highway is my major abutter.
All right. Any questions?
No.
Go ahead.
The spirit of the ordinance is observed. I'm using the building to house my antique tractors, vehicles, other personal uses. It's not for commercial use. There isn't going to be people moving into the building, so it wouldn't be, I shouldn't expand upon that, right? I should wait until you ask me questions.
You know, no, it's.
no, go ahead.
Feel free to
it's
expand.
all right.
All right, sorry. Basically, I know the spirit of the ordinance is not to create overcrowding, and the structure fits within the building box, but I'm not using it. It's just for my personal hobbies, and not to move people inside of the structure to add, more people.
Know
into
exactly
the
what
lot.
you mean.
So,
Okay, any questions? And when it comes to boys and their toys, I know what you mean. Go ahead with the next one.
okay. Granting the variance would do substantial justice because we own the house next door. It would allow us to use more of the property for the purposes we enjoy. Right now, and I can sit down?
Yeah, you can explain.
You can expound on it.
It's
yeah.
all you. She
all
told
you.
me early, when I signed out the thing that I could
You
only
gotta
read
sell
what
it,
was on it.
you gotta sell it to us.
Okay. Right now,
And don't be nervous. We're not mean or anything. We're more than willing to listen to you.
And everyone else can wait.
right now, we have a pool in the backyard, and this house for 20 years has been like a junkyard. They've had all sorts of cars and trash, and they've been really terrible neighbors. And so we've been able to take down the trees now that we own it and make our yard a little bit bigger so we have more grass for the kids to play. But the highway is very apparent now. You can hear
Don't you
all
find
the
it
noise.
very loud there?
Yes. And so I was, I've applied with the state to try to see if we can build some sort of berm to try to knock that down a little, but this structure will help knock the noise down from our yard also.
Any questions? All right, go ahead.
For the following reasons, the values of the surrounding properties will not be diminished. I actually believe they will be increased due to the quality of the construction and the cleanup of the property, which has been occupied, I guess, by hoarders. I wrote it there, for the last 20 years. But I do have, I don't know if you got a chance to drive down the
Oh, yeah,
street,
we went
so-
down there, yeah.
So you can see my house, which is right before that on the right-hand side, and the house that you saw with the Tyvek on it, I've ordered from Reed's Ferry cedar shake siding, so that will wrap that first house, and I have designs from Matt Pekarsky that'll show you that it is a good-looking structure in the back, red cedar shakes and clapboards on the bottom, so it's all wood. It should bring the property values of the surrounding
All right,
neighbors
Tony,
up.
you have a question?
I just out of curiosity, you gonna knock that garage down?
Am I going to lock it down?
No, you're gonna knock it down.
Oh, yeah, that's the...
How about take it down?
Take it down.
Yeah, I was going to add to it, but when I dug down, it's on cinder blocks, 3 feet of cinder blocks with no footings.
Okay. Just curious.
Yeah.
And you should have one more here.
Yep.
Okay, this is the...
Just take a deep breath.
unnecessary hardship. Owing to special conditions of the property that distinguish it from other properties in the area, denial of the variance would result in unnecessary hardship because, 1, no fair and substantial relationship exists between the general public purpose of the ordinance provision and the specific application of the provision to the property because I believe that the other homes in the area have large garages, and ours will actually block out the noise and visibility from the highway, adding to quiet enjoyment of our property and the neighbor's property also, because I think it'll knock down the noise. And as far as the ordinance goes, our property, like I said, it's a garage. It's not going to be a dwelling space for people to move into, so it's really storage and hobby.
And also, it's cleaning up the neighborhood.
Yeah, that's for sure.
All right. Any other questions or comments from the board? Well, I'll open the public hearing, and I'm going to close the public hearing. I don't think you want to testify again. And could I hear a motion on...
Motion to approve Frederick and Christine Hayden at Donzi Realty LLC petitioner owners variance under section 1.03A3 of the zoning ordinance to permit the construction of a 5,000 square foot garage/barn not incidental and subordinate to the principal dwelling residence. The parcel is located at 7 Priscilla Lane in the C1 Limited Commercial and Aquifer Conservation District's tax map 6D-2 lot 004, case number 2014-56, with staff recommendations that approval of case number 2014-55, which we're going to hear in a minute, seeking a variance to permit the construction of a 5,000 square foot garage barn within 13.3 feet of side property set line, whereas 20 feet is required.
Second.
All in favor, say aye.
Aye.
Anyone against? 500.
Thank you.
And if I could have my paperwork
Yes.
back, and we will go on. I think you said you had 55 there. Okay, it's number 55. Thank you. Wasn't so bad, was it?
No, thank you.
Right, Frederick and Christine Hayden in Donzi Realty, LLC, petitioner owners, requesting a variance under Section 3.02 of the zoning ordinance to permit the construction of a 5,000 square foot garage barn within a 13.3 foot of the side property, whereas 20 feet is required. The parcel is located at 7 Priscilla Lane in the C1 Limited Commercial and Aquifer Conservation Districts, tax map 62, lot 004, case number 2014-55. And you just got to read those again now for this
Okay.
one. And again, if you want to elaborate on it, go ahead on
Okay,
each item.
thank you. Number 1, granting the variance would not be contrary to the public interest. The side setback is against the highway property. No structures will likely be built on the state land, and no person will be moving to that property. The structure will act as a noise barrier from traffic, and the land on that side is really not suitable for quiet enjoyment. I am asking to place a new structure no closer than the one that exists, only 30 feet longer. The reason, if you look at the plan that is there, there's a leach field in between our two properties, and if there's already a structure there that's inside the one that I'm going to tear down, but if I could keep it on that line, it would allow me to stay further away from my leach field.
That and those the distance between the side of the lots is really intended for, so that you're not bothering your neighbors, and your neighbor's a highway. I don't think the highway would be offended with your building being too close.
Yeah.
I have a question for
You're good.
development, community development. Does the state have to be notified that something's going to be built within?
They were notified as part of this.
And there's obviously no comment from them? Okay. Can they come back and say something? Okay.
But that's within 30 days. It'd probably take them longer than that to get back to us, knowing the state. Go ahead, sir.
Okay. Number 2, the spirit of the ordinance is observed because I will not be affecting other neighbors' privacy or view. Also, again, I believe this actually isn't in the buildable box. It's a little bit outside, but it's a garage, not a living space. And it's addressing the overcrowding concerns. Nobody will be moving in, just my antiques.
Everyone all set on that? All right, go ahead with number 3.
Number 3, granting the variance would do substantial justice because it would allow us to use more of our yard for quiet enjoyment from the highway noise. And also, I won't have to drive on my leach field if it's closer to the highway. If it's within that inside that setback.
All right, number 4.
Okay. For the following reasons, the values of the surrounding properties will not be diminished. The new structure will be tastefully done, built, and add value to the neighborhood. 3 of the 5 houses on the street already have similar sized garages or barns. Okay.
Yep.
Number 5, unnecessary hardship. Owing to special conditions of the property that distinguish it from other properties in the area, denial of the variance would result in unnecessary hardship because no fair and substantial relationship exists between the general public purpose of the ordinance provision and the specific application of that provision to the property, because other properties do not rest against a highway with increasing traffic flow every year. Our property seems to be, as the highway gets busier, our noise level goes up. So
And I'm sure you hear every accident that occurs in that area, too.
there's not really a whole lot of accidents, but the traffic backup in the morning seems to get worse and worse going southbound.
Yeah, northbound, it's in the afternoon.
Yeah.
Yeah, I pulled into that driveway, and I've got a full-size SUV, and with 3 pickup trucks, one behind the other, and
Yeah.
it was a little hairy backing out there.
Yeah.
So, anything further from the board?
Are you going to keep the house that's there? Or?
Yeah, the little structure,
Yeah.
that's the one I was talking about. I just ordered all new cedar siding. We
Okay.
did the roof, and hopefully
it
one of
be
my
rent?
daughters will want to move into it
All right.
later
Yeah,
on
'cause
in
we
life.
were wondering, because Tony and I went out and pulled in, and we thought those were the workers' pickup trucks, because we thought the house was being, resided.
It is. It might have been this morning.
No, this
No.
was
Oh.
Monday morning.
Oh, there's across the street. They're doing that. The Lynhams are doing a big garage. That probably was there. I told them they can park. We're not over there, so.
Oh, okay. Yeah, because there was some sort of construction or something going on at the time. Well, again, I'm going to open the public hearing, and it looks like I'm going to be closing the public hearing. And is there any other further discussion?
Motion to grant.
Go ahead.
Motion to grant Frederick and Christine Hayden and Donzi Realty LLC petitioners owners variance under section 3.02 of the zoning variance to permit a construction of a 5,000 square foot barn within 13.3 feet of the side property line, whereas 20 feet is required. The parcel is located at 7 Priscilla Lane in the C1 Limited Commercial and Aquifer Conservation Districts, Tax Map 60-2, Lot 004, case number 2014-55.
Second.
Any,
Staff approval.
Oh, yeah, Steph.
And that is under the condition that approval of case seeking variance for a garage barn not incidental and subordinate to the principal dwelling residence.
which we did, so we're all set. Okay, all in favor?
Aye.
Anyone against? 500.
You have 30 days to just, somebody can appeal, so at your own risk if you do it within the first 30 days.
That's the picture, by the way, if you wanted to see there.
That looks,
That's beautiful.
that looks nice.
That's nice.
Looks nice. That does look nice.
Have a Merry Christmas.
Yes.
Thank you.
Yeah,
And you
very
guys
Merry
also.
Christmas and Happy New
New
Year.
Year.
Yep.
That was my first experience, and it was very nice, so thank you.
Oh, we have one other item to take care of. Since Mr. Duggan or Dugan
Oh,
from...
I'm sorry, I didn't mean to interrupt, Mr. Chair. Did you sign in? Okay, good. Just making sure. Sorry.
Of Metro Sign and Awning for Go Wireless. Our case number 2014-50 did not show up. I'd like to have a motion to table this until the next meeting.
So moved.
And second? All in favor, say aye.
Aye.
Anyone against?
Tony, was it second? Fran made the motion.
No, I didn't make the motion. I just,
Tony made the motion. I was gonna say what she said.
I'll second it.
Okay, Rich, thanks. Water on me tonight.
okay.
I don't know what that means.
So we can drink it. I'm gonna drink water until.
Firewater.
Do we have any other discussion or possible actions or any concerns that anyone would like to discuss?
I actually, well, given that we made that, we had the appeal come in for Mr. Bevel. I mean, is this something that we're starting to see more and more of as community development, starting to see more and more gunsmithing? I mean, is that something that we should look at as something to get added into the zoning?
I want to say the last one that we saw was at least 7 years ago. I'm just doing that off the top of my head, but in my knowledge, I don't think that we get them very often.
Well, the appeal, the intent of the appeal just did not seem like a valid intent.
And I understand that. It's just that this conversation is coming up with planning boards and zoning boards throughout the state, and it's becoming more of a quote-unquote hot button issue for towns. I know there are other towns around us that have faced similar questions. I'm just looking at the future, looking at Merrimack. Is it something that we just, instead of addressing it each time, which we can do each time, it's perfectly fine, or do we maybe look at it, maybe being a little proactive and say, we're gonna set this, we're gonna put a requirement into the zoning laws.
Well, I think that there's two sides to that, because if you recall, the gentleman who was building or wanted to work on repairing as a gunsmith in his house, he had mentioned that he was going to be repairing the weapons of families and friends of his, so it didn't sound like he was talking about being open to the public. And in reality, if he's not running a business, then he would need to do nothing, and he could do exactly what he's talking about, and he wouldn't need the metal cases, he wouldn't need any of that, he wouldn't even need a key, he would need nothing, absolutely nothing. So, I think that the amount of, I would say, the amount of regulations that were put on him by the planning board some may say that's kind of harsh. Maybe it's not. But the reality is that if he's really servicing people that he doesn't intend to charge, he doesn't have a business, and we don't have to put any requirements on him. So why?
And I'm not talking, again, not talking specifically about this case. I'm talking about future cases. I'm talking about other cases out there. Because, I mean, now, the next time we see it might be 7 years from now. Next time we see it might be 7 months from now. Okay? It's one of those things that, is it something, and all I was doing is putting out the question, is it something that we should consider as part of the zoning board, as part of the zoning board of town of Merrimack? Is this something that we should consider, or is it something that, like you said, planning board put in the restrictions, it's a case-by-case basis, last time we heard one was 7 years ago, and, it's a moot point. All I know is that the timing of this compared to what we see, I think recently there was one in Ware, and there was one, I think, in Londonderry. I mean, there's just been, seems to be a couple more of them popping up recently. Maybe it's just a recent thing. And I just was opening the discussion to see, is that something we should potentially address?
Are you saying the small businesses in the residential areas, in a home?
Yeah.
Or do you feel, or are you just saying gunsmith?
I'm referring to the specific paragraph that refers to home businesses in a residential area, not gunsmithing in general in Merrimack. I'm talking about just in the residence. And I personally, I agree with what's written right now, but is it something? I mean, as part of our jobs is to look at what we're seeing as trends, and is it something that might need to be revised? Since and I'm just opening it from that discussion. I'm not for or against it either way.
Well, I would imagine that staff would keep us informed if they see more and more of this coming aboard, coming into the town, and say, gee whiz, you guys, we're getting more and more of this. So maybe we should take a little more stronger look at it. But as far as I know, since I've been on the board, there hasn't been too many things like this.
So, just out of curiosity, and you may have a very valid point. How do you think the actual ordinance could be phrased differently to better explain? I mean, because I guess if we're going to discriminate it, business by business, then we could build a dictionary here talking about what businesses can and can't.
Absolutely right.
And so, if we get right now, it may have a relative level of vagueness to it. However, how could we scrutinize it to that point?
And I don't have an answer for it. That's why I was bringing up a discussion. And you're absolutely right. We could probably fill 4 or 5 pages up in the zoning book, just home businesses, and again, what right do we? The argument could be, who do we say what is and isn't a legit home?
I would
business?
imagine, though, if more and more come in, the staff will have some kind of structure to present to the ZBA, so we can say, well, this is what we like, this is what the staff would like to see, and then we could discuss it and maybe add on or distract or whatever.
Lynn, would you, if you could, maybe for the next meeting, have some sort of list of how many home businesses there are in Merrimack, and maybe break them down to like what they are, whatever they've applied for.
Yeah.
And what year they were established, maybe. And that might give us a better idea.
And again, I'm not trying to put anything in place. I'm just having the discussion. If everybody thinks that we don't need to discuss it's case by case, hey, I'm all. I'm not trying to parlay anything. I don't know. I guess spitball on this.
I would be curious, though, on the gunsmithing, where this is becoming so controversial at this point.
Yep.
To see if there's been any problems with the police department on this. If they've had any calls at the already established gunsmithing shops.
I think Tim has a lot of that information. He seemed to have a lot when the case is being presented. I think he has a lot of that.
He's done a lot of that research, and you look at the planning board memo that he put together for the original home occupation application to the planning board. A lot of it's in there, but I can certainly put a summary together.
It's something separate that we all could have as a reference, I think.
Sure.
Would be good.
And like I said, we may not see another one for 7 years.
We might not see one in our lifetime.
We could have another joint meeting and discuss it.
Next item.
Yes. Approval of minutes. Do I hear a motion or any corrections? I looked through it and I didn't see anything.
Chairman, I make a motion, we accept the minutes of November 19, 2014, as written, and discussion.
Second.
Any corrections? Do I hear a motion?
Motion to accept.
I second that.
Please.
Third?
Third.
Third, and
Fourth.
fourth.
Tony and Patrick. All right, the big question of the night.
Motion to adjourn.
Second.
Look, that was delayed. All in favor?
Aye.
Anyone against?
Can you get that back?
500.